This is the current federal tax developments for the week of October the 24th, 2016. Current federal tax developments are brought to you by Nichols Patrick CPE and your state society of CPAs. This week we're looking at can't escape the lien. Current federal tax developments are what we look at every week, the issues that come up and the issues that develop this week in taxes. And this week we're going to look at a few issues. First, we're going to start out with the issue that the IRS began with their audit guide. So we have the updated IRS Audit Technique guide for capitalization issues. As well, we have an issue where the IRS has granted some relief to retirement plans that have been given flexibility to assist participants that were affected by Hurricane Matthew. We'll find a memo from the IRS that talks about what happens if you omit prior year gifts on a Form 709. Does that leave the statute open forever? A former spouse discovered the hard way that merely because you got the asset in the divorce doesn't mean that that asset got released from the federal tax lien from your ex-spouse. And we'll also discuss, is Inauguration Day a holiday for federal tax purposes? We actually have an email that came up and discussed that issue from the IRS. So we have lots of things happening today, and we'll go ahead and we'll start with this week's session. First thing I want to mention is I'm going to be on the road here shortly, and I'm going to be going into Missoula, Montana this week. On the 27th, I'll be talking about construction contractors. And on the 28th, I'll be doing depreciation, repairs, and fixed assets in Missoula. So if you're in that area, you can go ahead and sign up. There's still time to get in and get signed up for that course coming up here this Thursday and Friday. The following week, on Monday and Tuesday, I will be in Twin Falls, Idaho. I'll be doing current federal tax developments, the individual update on October the 31st, and I'll be doing the business portion of the update on November the 1st. So you have 2 days worth of tax updates in Twin Falls, Idaho. So if you want to go to Twin Falls and go through the updates, I'd look forward to seeing you there. Now let's go ahead and start taking a look at this week's developments. And first, we're going to start out with a document the IRS updated that really was updated because of regulations that took effect back in 2014. The IRS issued a revised version of the Tangible Property Audit Guide. The old guide had been superseded because the regulations that it depended on no longer existed. Now they've come out and brought this guide forward. Remember, these new rules took effect for tangible property for tax years beginning on or after January 1st, 2014. If you were a small taxpayer, you qualified, you didn't have either $10 million of revenue or $10 million of assets, you basically could just start using the new method for things you acquired from 2014 on. If you were above that level, you had to file a change of accounting method form, Form 3115, to change over to the new regulations and treat those regulations as if they'd always applied to your return. Well, now the IRS apparently is ready to start examining people on this. The PDF in this case is over 200 pages and actually has a fairly good and fairly thorough discussion of the issues related to those regulations about what you have to capitalize and what you could go ahead and expense off as a repair. It also tells auditors specifically to take a look at whether the 3115s were properly completed and filed, and also to take a careful look at the 41A adjustments that were computed for entities that did file 3115s. So if you want to, if you have an issue or if the agent starts coming, looks like the IRS is ready to start talking about fixed assets again. Certainly it would make sense to take a look for your clients, to take a look at this guide and make sure that you understand what the agents are being told to look at now with regard to fixed assets so that you can properly advise your clients in this area. Next up is announcement 2016-39, issued on October the 21st of 2016. This announcement is meant to allow relief to individuals who basically have suffered damages from Hurricane Matthew. Individuals in the affected states per FEMA, and that's going to be the first test, you got to check and make sure you're in an affected state, affected county. Qualified retirement plans, that is things like 401ks, 403bs, 457 plans. The IRS has announced that they would be allowed to either make distributions, hardship distributions, or they could make loans to individuals, even if the plan document doesn't yet contain any language that allows for hardship distributions or loans. Rather, the IRS will let the plans go ahead and make those transactions today, and as long as they get a plan amendment adopted retroactively in the near future, they'll be able to, they won't worry about the fact that they didn't have any documentation to back this up as of the instant where these loans were issued. As well, even if you do have the document, if you do have the information in your files, the IRS has allowed you to waive initially having to get all the documentation to back up that somebody qualifies for a hardship distribution or for a loan before the loan or hardship distribution is made. You will be allowed to get that information as soon as practical after the loan has been made. Those are both meant to allow individuals who need funds from their retirement plan, who have been affected by Hurricane Matthew, to be able to get that relief without having to go through and jump through tons of hoops, or having it stuck in a retirement plan and they can't get to it, and the plan has to go through a number of weeks or months of time getting things amended for this to happen. This is meant to allow those funds to get out of there quickly if the plan decides that's what they want to do. One thing to note, though, we do not change the tax treatment of these distributions. Therefore, if an individual is under age 59 and a half and takes this distribution, the 10% early distribution penalty is still going to apply as well. If merely fact a hardship distribution doesn't get you out of the tax either. If it's a loan, you've still got to comply with all the requirements for loans, and that means, of course, timely paying it back or treat it as a distribution. No relief is found for those issues. Any relief in that area would have to come from the U.S. Congress, and we'll have to see if Congress would decide at some point that this is what they'd like to do, but for now we have to assume they won't. Chief Counsel Advice 2016-43020 is next up. It was also issued on October the 21st. This is a case of a problem with the Form 709 that was filed. The 709 reported taxable gifts, and this taxpayer had reported taxable gifts for many years. But in the year in question, the 709 had been filled in, but the prior year's gifts had not been filled in on a 709. As you might expect, that caused let's say, a substantial understatement of the tax due on the return, because, of course, all those prior gifts kick you up into the tax brackets. So we're not sure whether it meant none of the gift was treated as taxable or just a small portion was treated as taxable, and the whole thing should have been. Now, the only problem the IRS had was the IRS agent who basically asked for this guidance from the national office was that the IRS had not caught the fact that this was missing until more than 3 years had passed from the date for filing that return. So the statute of limitations for collecting tax was normally closed. However, there is a special provision for gift tax returns found in section 6501C9 that states that if there is a gift omitted from a gift tax return, the statute effectively never closes. The IRS can assess the tax on that omitted gift at any time. The IRS agent was asking the simple question of, can we use that provision because they omitted the prior gifts? Does that mean that we still can go back and recover that tax? And while you can read the code section and see how the agent decided that seemed possible, the national office concluded, nope, that's not what that section is meant for. The national office specifically concluded that that section was meant only for gifts that are left off of the return for the year in which this gift is given. That is, the gift to which tax would be assessed upon. That gift was on there. Also, as the memo notes, so it didn't go further this analysis, even if it was omitted, if there's a disclosure that makes the IRS aware of the gift, then that also would cause the statute to run. My guess is, even if you could convince yourself that, well, it wasn't on the return, so the statute should be extended, because these gifts had been reported on all the prior returns, I suspect the chief counsel's office would be concerned that at trial, the court would say, well, IRS, you were on notice. You had all the information you needed to know that these guys had not properly filled in the 709. And really, it's bad for you that you didn't notice this until more than 3 years was out. But, ladies and gentlemen, that's why we have statute limitations. The IRS doesn't get forever to go after these things and try to figure out how to get the money from it. In any event, it is an interesting ruling, and important also from time to time to recall that that section is in there at 6501C9. If you prepare a gift tax return and the gift is not reported, the statute never closes. It's not the case that merely by filing a gift tax return for the year in question, you shut everything down. If you leave a gift off that return, that leaves the statute totally open for that gift. So it's important to make sure that all gifts, even things you think might be gifts, or maybe the IRS might conclude at some point might be a gift, all of that should be disclosed on the gift tax returns when you prepare one for a client. The next case up is a case of United States versus McGrew et al. This is a Ninth Circuit case, 118 AFTR 2nd, paragraph 2016-5319. This case came down on October 17th of 2016. It is sustaining a district court in California. What happened in this case was that Mr. and Mrs. McGrew, basically they separated, they moved out, everybody moved out on their own in 2002. They finally got formally divorced in 2006. Now, during this time period, there were various tax problems, mainly for Mr. McGrew, that took place. In 2009, 3 years after the divorce was final, it took a while to do this, the couple divided their community property, and Mrs. McGrew got the residence. Now, what's happening now today and why this case is in front of us is the IRS now has decided to try to foreclose on the tax liens. And the IRS said the tax liens attached to Mrs. McGrew's residence. Now, Mrs. McGrew protested that, no, I got this in the divorce, and these are my husband's liens. Well, in fact, one of them really isn't, because the 2000 return apparently was a joint return. So good old joint and several liability comes after Mrs. McGrew here. So there, in essence, both halves of the community were at fault. And under community property law, that means that the whole asset is available to satisfy a 2000 debt. For 2001 through 2005, apparently they filed separate returns, and the unpaid tax was Mr. McGrew's. In that case, though, as the court notes, essentially, since it's his separate property, that would mean that his liability could attach to 1/2 of the community interest in that residence. And the court noted that these liens, basically, as soon as the tax is assessed, a lien becomes good. And the problem is, they said, these liens took effect well before there was a cessation of the community. It took place while these assets were part of the marital community, and therefore the IRS has the full right to seize the property. This sometimes causes client trouble because people have to remember that legal proceedings where the IRS is not a party to the proceeding, well, basically, that doesn't really put any limitations on the IRS or on the IRS when they go to collect things. Because the catch was, what divides is between your rights, the two spouses' rights, but if a third party has a right in that property, that third party's right is generally not affected by the divorce agreement. I'm sure Mrs. McGrew was surprised at that answer and, probably isn't too thrilled with it. But nevertheless, it clearly appears to be the right answer in this case, and it is something to keep your eye on. Now, this was a community property case, but theoretically, it would appear that much the same would occur in other jurisdictions as long as you had property that at the time the lien came to pass, that spouse could, in essence, that spouse had a right, any creditor of that spouse had a right to grab the asset. Merely running through a divorce almost certainly wouldn't really change anything. Finally, for this week, we didn't have much happen this week. It's been a very quiet week. We have a chief counsel email for an unusual issue that you might not have thought of. As you may have noticed if you've watched TV recently, or even if you haven't, you just can't really avoid it, whatever you do, there is this thing called a presidential election going on. You probably have heard about it. Well, because of that, we are going to have the presidential election, and next year, on January 20th, the presidential election will come. And what's going to end up happening is we're going to have an inauguration on January 20th, where we will inaugurate presumably one of the people running today. I realize with the Electoral College, it's always possible that we could actually elect somebody else, but let's presume that doesn't happen. And let's also presume that neither Gary Johnson nor Jill Stein are going to be able to catch up to that. So we're going to have an inauguration probably of one of the two major party candidates. The question becomes, what if your tax court petition is due on that day? Or what if you have a payroll tax deposit due on that day? Is it really due on that day? Well, it turns out, not surprisingly, when you think about what a mess it's going to be in the city, that the District of Columbia treats Inauguration Day as a city holiday. because you really couldn't get much done while everything's shut down. They have this big inauguration and securities everywhere for the inauguration. So because of that, that's a holiday. Section 7503 of the Internal Revenue Code provides that if the due date for doing something, the date in which some action needs to be taken, falls on a holiday, and they look at the District of Columbia's holidays as a holiday, that's going to move the date for the action to be taken to the following day. Well, in this case, it'll actually move it to the following Monday, because the 20th this year falls on a Friday. So the 21st will be Saturday, 22nd will be Sunday. So the 23rd will be the date for anything that we do on the 20th. This email concludes, yes, that it's correct. Apparently somebody had said, is this right? Is everything going to be the 23rd if there's a due date? The email concluded that yes, that this is right. It will be the 23rd will be our due date. So anything like a tax court petition that falls due on that day, let's say you had a claim for refund where you had previously filed earlier, 2 years earlier. So now you got to file the formal, you got to file for the money back within 2 years. So this is when your claim for refund date would pass, would be that 2-year date. Any of those that fall on that date, the actual date where it has to come in is going to come on the following Monday. So just in case you have that situation, and probably not many of you do, have something magically that's going to come due on January the 20th, maybe payroll tax deposits are the most likely thing, things are going to move back one day. Well, it's that time of year again. We're getting to the time where we have all of our training and time comes up. You've now finished your individual returns. Hopefully you have. I mean, if you got anybody straggling now, they're just late. So, you take care of them as you can. But it's time now to get ready. Tax planning season is going to quickly approach on us. And unfortunately, we can't really get a timeout easily to stop the clock for long periods of time so that we can get everything we need to do done. This is the time you want to make sure you take a look at your state society catalogs if you haven't already done so, and find those courses that are going to help you plan with your clients for their 2016 taxes. Your state society's catalog has a lot of full day courses. Also, most state societies offer other methods of getting your education. But the full day course is always kind of interesting because you're able to interact with other people in the classroom, which is always useful, and you're able to ask specifically questions of the instructor during the day. I know that's always interesting, and I always find that enjoyable when I'm teaching those courses. So be sure to check that, consider your state society catalog, and be sure you go ahead and consider signing up for those courses. This has been the current federal tax developments here for the week of October the 24th, 2016. You can check out our updates during the week at currentfederaltaxdevelopments.com. That's where we'll post articles as things happen during the week. If they happen, as I said, this week it was almost nothing of significance. The thing for most of the week that we had happening was IRS information letters, which were really nothing to write home about. Where they were just, telling congressmen that, yeah, I know it's unfair. This tax law is unfair, but, constituent, we really can't do anything about it. So we didn't have much in that. That's why this week we're a bit short on it. But we'll hopefully have some more happening over the next couple of weeks as we get ready for the new year to come in, and the IRS will start getting a few other things out. So hopefully a bit more will start happening. You also can download the full write-up of this week's documents because I've got those written up for you. They're available for you at currentfederaltaxdevelopments.com. And as well, if you want to, you can go ahead and send any questions or comments to me, Ed Zollers at currentfederaltaxdevelopments.com. You can also follow me on Twitter. I'm at Ed Zollers. So be sure to take a look. If you're going to be in either Missoula or Twin Falls coming up here shortly, be sure to consider signing up for those courses. Otherwise, I'll see you back here next week when we'll record another session, and we'll talk to you about what happened this week in the area of federal income taxes.